Should Joe Biden forgive all student loan debt? And what should you do if you get arrested? Hang out with us, and we're going to answer those questions.
That Corbin and Corbin legal team fighting for the rights of the people. That father-daughter team investing in the youth when the system ain't treating them equal. Providing truth for our people, we able to reach them. So anytime you get accused for a crime and Lord knows you ain't do it, we here to get you through it. Exemplifying prudence and glorifying God, making sure you're compensated for other people's doings. Our vision is to be one of the best. We're small enough to focus on your matter throughout the neighborhoods of Dallas. Working constantly and making sure your rights are protected. A firm team of lawyers, aggressive, effective. A team that has your back in the courtroom. Two well-spoken black lawyers in the courtroom. Investing time and resources when it's evident that you were treated wrong. Now you walking out of Dallas courtroom with a settlement. Corbin and Corbin, the father-daughter legal tag team that has your back in the courtroom. Our purpose is simple. To obtain the favorable outcome for each client and glorify Christ in all we do. Our vision is to be one of the best and most...
Hello, legal rebels. This is Attorney Augustus Corbett, a.k.a. the Minister of Justice. And with me, I have the pleasure of having...
Attorney Chloe Corbett, a.k.a. the Duchess of Justice.
And together we are the Defiant Lawyers. We provide legal analysis of trending politics, policies, personalities, and pop culture to provide you the information you need to defy this unjust legal system. Go ahead, subscribe, like, and share. What are you waiting on? This is the place to be every Saturday between 2 and 2:30, 3 o'clock sometimes. Look, you know, we're busy lawyers and everything else is going on, so we don't get on when we want to, but you be open to be with us between 2 and 3 o'clock every Saturday afternoon. This is a labor of love for us. We enjoy doing it. And so we got a very good show for you today. You know what? This is the only place that I'm aware of on YouTube that you can get legal and social justice news from the African-American perspective. So if that's important to you, again, subscribe, like, and share. Hey, Chloe, how you doing this morning or this afternoon?
What's up, Dad? I'm doing good. It's a beautiful day outside. I'm glad it's Saturday. Glad to be talking about these topics and to have this discussion with you today.
Very good. So when you said it's a beautiful day outside today, I know that was really a little subliminal message. Let's get this show done, get it over so I can get out in that beautiful day. I hear you.
You know who reminds me of that? My dog, Grace. So
okay.
She's going to, yeah, she reminds me constantly. She wants to go run.
Yeah. So we don't do this fast. She's going to start barking and let everybody know she's ready to get out the house, right?
Yep.
Well, at the moment, Grace is the only grandchild I have, so.
You and Mom love to bring that up at all times.
So I guess, I guess Grace Corbett, it is what it is at this point. But we got several exciting topics that we want to talk about today. Student loan forgiveness and what to do if you get arrested. All right. And both of these topics are very relevant and applicable, very germane to the African-American community. So we want to get into them and talk about them. And so why don't you start us off with the student loan forgiveness? I do have a few slides I want to show. So let me do that, and then you can take us away.
Okay.
All right. So, we're on the screen. There are just a couple of things. Oh, boy. That didn't work out right. That didn't work out right. That sure enough did not work out right. I don't know what just happened, but we'll get that straightened out. So go ahead and talk about student loan a moment. Let me find out what just happened.
Look, I've been on President Biden's behind to try to get on this student loan debt issue for so many months now, especially being a millennial who has student loans of myself. And a lot of my peers and a lot of millennials, I know a lot of people that have student loans, and he's been kind of resistant, he and his administration. So, there was some news that broke out recently from Bloomberg that Biden may be considering student loan forgiveness, but he is considering it, according to this reporting, at $10,000. Senator Elizabeth Warren, she has been a vocal, outspoken supporter of student loan forgiveness at a minimum of $50,000. And then there's even more progressive activists who want President Biden to completely eliminate student loan debt. I fall more into that spectrum. I would like this administration to completely eliminate student loan debt. But look, we get what we can get for right now. President Biden has been resistant to student loan forgiveness of $50,000, but it looks like he may do something um, for forgiving at least $10,000 with student loans. And let's keep it real, we're getting close to the 2022 midterm elections. He's losing support among Democrats, among young people, Black people. He needs something to try to get his support up in the polls. And I believe that's why his administration is now talking about the student loan debt issue. So, according to Bloomberg News, the White House is considering forgiving at least $10,000 in student loans per borrower through executive action. So, he's not going to wait for Congress to do anything. He's going to try to do it through his own executive action. And apparently, this administration has not yet settled on the particulars of the move, but he is looking to do something at least in the $10,000 range. And the reason why we wanted to talk about this today is because the disproportionate number of borrowers of student loan debt are African Americans.
Yes.
And this is a huge issue that faces a lot of Black graduates, Black professionals, because on average, we borrow a lot more in student loans than white Americans, Hispanic Americans, and any other race in this country.
And let me just interject. The reason for that is because of the wealth disparity.
Exactly.
Yes, the wealth disparity is so great between Black Americans and white Americans that, the average Black family cannot go into their equity or their 401k, their mutual fund, or their mineral interests, or whatever white families typically have, and just cut checks for student tuition. So
Yep.
that's the reason for that.
Yep. They don't have, a 529 college savings funds for their children, or, real estate that they can try to liquefy and other assets. And that's why we have to borrow so much. In fact, Bloomberg reported that nearly half of Black students owe an average of 12.5% more than they borrowed just 4 years ago. And during that same period, 83% of white graduates owe 12% less than they borrowed within that same 4-year period. And in fact, over half of Black student I cannot say that word, borrowers report that their net worth is less than their student debt balance. Think about that, Dad. Wow.
Yeah.
Their
Read it
net
again.
worth is over half of Black student borrowers report that their net worth is less than their student loan balance.
Wow.
So basically, they have more debt than they have net worth.
Yeah.
And as we know, your net worth is your assets minus your debts that you owe, whatever you have left. I mean, that's just crazy to think about.
Yeah, when you connect again the wealth disparity with this issue, then you see why Black Americans should get, to me, in fact, I'm going to say something about that in just a moment, should get more relief in student loans, because the wealth disparity has been brought about from 400 years of of systemic racism, of slavery, of Jim Crow, of white supremacy.
Yep. And what this article also reported is that a lot of people who have technical degrees or associate degrees, a majority of whom are Black, this $10,000 could completely eliminate their student loan debt.
Wow.
And that would affect millions of Americans and millions of Black graduates and Black people in this country. So even though it may not be exactly what I want, $50,000 or complete student loan forgiveness, I recognize that just eliminating $10,000 for each borrower could really have an impact on the Black community.
Huge impact.
And look, the the less that we have to try to put towards paying off debt and paying off student loans, the more that a graduate could potentially start a business or use that money to invest in real estate or use that money to invest in another entrepreneur and potentially make the wealth gap even smaller and put more assets and money into our own community. So I hope that is what occurs, and I hope that President Biden actually does this.
Yes, some other things that Biden and the education department are doing or have done in some cases, they are revising the IDR, which is the income-driven repayment that will reduce payments for millions of borrowers. And of course, the Biden administration announced a week or two ago that it was extending the amount of time that the payments are due until maybe September?
Yeah. Well, actually, I just got a notification August.
Oh, August. Okay. I knew it was a few more months because it would have started in April?
Yeah.
Yeah. So that, I guess that's the amount of time they need to figure out exactly what they're going to do.
Yeah.
And I'm so happy to hear that all this is going to happen by executive action. The GOP can't stop it. Biden is just going to do it on the strength of his pen. And of course, we're already hearing the naysayers, saying this is going to have a negative impact on the economy and all of that. Well, listen, let me just say about that very quickly. All those are talking points that are coming from ultra or uber wealthy people who are getting those talking points out through Fox News, through other conservatives, and they always have something to say when there's some initiative to try and help working people, middle-class people. They don't have anything to say when it's $1 trillion or $2 trillion tax cut to benefit the top 1% of 1%.
Yep.
They never have anything to say about that, right? But when it comes to student loans, when it comes to Build Back Better, when it comes to anything to help the working man, the middle-class family, here they come. Here come the trolls. So some other things that the Biden administration is doing with student loan forgiveness is they have forgiven about $17 billion in debt for 725,000 borrowers, and again, extending the student loan repayment plan. They also forgave $6.8 billion for more than 113,000 public servants, teachers, police officers, so on. That's a beautiful thing. That's a beautiful thing. They forgave $7.8 billion for more than 400,000 disabled borrowers. I mean, that's great. No one should be opposing that. That's a wonderful thing. They forgave $1.2 billion for borrowers who attended ITT technical institutes. So one of these schools that went out of business. And they forgave nearly $2 billion for about 105,000 borrowers who were defrauded by their school. So all that's great, but I agree with you. That is not enough.
It's not. We need more. President Biden, we need more.
In fact, according to Bloomberg, and we both are citing this information from Bloomberg News. Bloomberg says erasing $10,000 per borrower would require the government to cancel about $320 billion in federally backed loans, according to an analysis published by the Federal Reserve Bank of New York last week. That would benefit about almost 12 million borrowers, or roughly 31.1%, and cancel 30.5% of loans delinquent or in default prior to pandemic forbearance. Again, that's Bloomberg News. And like you said, a disproportionate percentage of these people are African Americans. Now, that brings me to what I want to suggest or propose in addition to all of this. As a form of reparations, I think there are several other things that Biden should do through student loans. Number one, Biden should completely cancel the student loan debt of every African American who can trace his or her descendancy to slavery. Okay?
Yes.
Completely cancel the student loan debt of every African American who can trace their descendancy directly to slavery. In my case, I can do so on both sides of my family. All right? And my family having come directly from slavery, I can go back to the fields that my family used to work in for a white family back where I'm from in North Carolina. I have the paperwork to show that my family was enslaved until, slavery was abolished. Now, other African Americans or other blacks in this country who cannot, directly tie their descendancy to slavery, I still think they should get further or additional loan forgiveness. But I don't think it should be as much as those of us who are direct descendants of enslaved people, number one. And number two, I think those people, those other blacks, should have been in the country for at least one generation. All right. Now, I'm not an expert in this. This is my opinion. I'm just generally suggesting that African Americans who have been impacted by slavery, all their debt should be erased. And then blacks who've been here who are not the direct descendants of slavery, have still suffered a whole lot of white supremacy and systemic racism, and they should get some additional loan forgiveness too, above the $10,000 that Biden is proposing for everybody. What do you think?
I agree. I mean, this would be a good alternative for reparations, which I believe that African descent.
I'm saying this would be a form of reparations.
Yeah, that's a better word, a form of reparations.
Mm-hmm.
I mean, this would be our 40 acres and a mule that we never got, that we were never able to get put on the right footing. And it's so fitting that it be related to education, because we know so many of our ancestors were killed, injured, and harmed for just trying to learn how to read and to get an education.
That's right.
So the fact that the government would forgive taking out loans to further our education, I think is wholly symbolic. I think it's great. And I do think there should be a difference between the black people who are descendants of slaves versus the black people who came here who were not exactly descendants of slaves.
Yes.
That is an important distinction.
Huge
Distinction. So I think that that's a great idea, that we need to put a think tank together and get it to the lobbyists and the people who do this for a living and see what we can get done.
Yes. I mean, it's long overdue.
It is.
There has been direct existential damage done to Black Americans who were descendants or who are descendants of slavery. We can show it in so many different areas, and this just would be a great way to to repair some of that. Now there are a lot of African Americans who never attended college, so they could potentially be left out of this.
That's
So
a great
what? Yeah. So what I would say in that case is, those folks should get, some tuition-free education, or some other way. They should still be compensated in some other way. Should be repaired. This shouldn't even be controversial, quite frankly, because in our law, if you harm someone, if you harm a person, be it negligently or intentionally, the law will hold you accountable and require that you compensate that person for his or her damages. And that's all this is.
That's literally what civil law is based off of. Civil law is based off of a person, a plaintiff, brings a claim against someone else, says that this person injured me in some way, and now I want to be repaired. That's simply what we're asking for and demanding that the U.S. government do. We were brought to this country against our will. We were tortured, killed, maimed. We were set back. Now we are going to the federal government and saying, you all need to repair us and try to put us back to where we started. That's simply what reparations is.
That's
So
all
there
it
should
is.
be no. I agree. There should be absolutely no controversy. Because if someone gets in a car accident and they go hire a lawyer, they're going to demand to get some money and a settlement on their case to get repaired. That's exactly what we're doing as Black people in this country. So I think that those are good proposals. We're going to be keeping a lookout to see what Biden does with the student loan forgiveness. It will, I believe, make a big impact for millions of Americans. I hope that he does even more. I hope he does more than the $10,000 that's floating around too.
I do too. That would be awesome.
Yes.
He made the promise, so keep your promises.
I want to give a shout out. I see Sean Breezy's up here. He said he's on the live. What's up?
What's up,
Thank
Sean?
you for joining.
Absolutely.
If you have any questions, any comments, please leave them down below. We'd love to interact with you all.
All right, let's see. We're going to move to our second topic because we don't want Grace. We don't want Grace getting mad with us. And I want to get out there myself.
Yeah, it's a beautiful Texas afternoon.
Yes. All right. So our next topic is equally important.
Yes.
For the Black community. And let me go to it. All right. What to do if you're arrested. So if you get arrested, what to do? Chloe, we cannot stress this enough. There are two very grave potentials if you handle an arrest, if you're Black and you handle it wrong. One, you can get killed. Two, if you're Black or brown, actually, you can get killed. Two, you can go to prison for a long time if you handle that interaction wrong. So we want to discuss it, and we discuss it against the backdrop of the LA riots. Okay. The LA riots occurred. Let me see. I remember it like it was yesterday. Think maybe 1994, maybe, which was the year Caleb was born. um, somewhere in the early '90s, and it it occurred, and I'm talking about in my lifetime. There were L.A. riots back in the '60s, which was also in my lifetime, but I'm talking about in my memory. It occurred because of the beating of Rodney King.
Mm-hmm.
Okay, the vicious beating of Rodney King. I still remember it like it was yesterday. And when it occurred, Chloe, as I watched those officers beat Rodney King, beating blacks was so commonplace by police officers. I remember asking somebody, is it illegal? Because if you were black and you got arrested, you got beat. Those three things went together. If you were black, you got arrested, you got beat. Simple.
Mm-hmm.
You were gonna suffer some injuries. Your lip was gonna get busted, your eye get blackened, something for no reason other than you're black. So when they did that to Rodney King, I was like, is that illegal? And of course it was illegal, but in common practice, it was not illegal. And that's why, in fact, all four of those police officers were found not guilty. And that brought about, the riots. And so, what to do today if you get arrested? Because there's still the threat of the police killing you if you're black or brown. And if they are investigating you for some criminal offense, you could say something that could result in you going to prison for a long time. So I cannot emphasize enough the importance of handling a police stop well. So we want to give you several tips to help you out.
The ABCs of what to do when you're arrested.
Yes. So if you're ready, we'll get started. The ABCs. So the A is ask for a lawyer.
Off top, guys, ask for a lawyer. The very beginning. First thing you do. I want to speak to a lawyer. I want to speak to my lawyer. I need a lawyer. Lawyer, lawyer, lawyer. That is the first thing that you need to do after you've been arrested, put in handcuffs, etc. We can't tell you how many people do the opposite. They talk first and then they ask for a lawyer later. No. You need to ask for the lawyer first and not talk at all. We'll go to the next letter next after this. But ask for a lawyer. A lot of people know, they've heard of Miranda rights. You have the right to remain silent. Anything you say can be used against you. You have the right to an attorney. If you can't afford, a 411 will be appointed to you. Some variation of that. Those are constitutional rights that were given for a reason. And under the U.S. Constitution, under due process, under the 5th and 6th Amendment, right to counsel, under the 5th Amendment, and then under the 6th Amendment, once adversarial proceedings have started, so once you have court dates and you start going to court, etc., you have the right to have counsel. You have the right to have an attorney. So you need to make sure from the very beginning that you ask for one and then shut up. That can save you a lot of problems if your case continues to proceed through the court system. So that's why we chose ask for a lawyer as the A of what to do when you're arrested.
All right. B is be quiet. So after you ask for a lawyer, then you need to shut up.
Shut up.
You need to zip it up. All right. So you ask for the lawyer. And at that point, if the officer, and I think we need to give a little backdrop here. Different states are different. There are some states like Texas that requires that you share some information when you are stopped for a traffic stop. Name, address, that you're obligated to give your driver's license. Anything more than that, you are not obligated to give it. I'm going to say it again. Anything more than name and address in the state of Texas, I can't talk about the other 49 states, but in the state of Texas, where we practice law every day, you are not obligated to give any more information other than your name and your address. And that is only if it is a traffic stop. If you're in a car and they pull you over. If you're on the street corner.
Before you go to the street corner, Dad,
okay,
I want to point out to people. So that means the officer comes up to you. Do you know why I stopped you? Where are you going? Can I look in your car? I want to search your trunk. Can you open the trunk? Can I search it? In Texas, pursuant to a traffic stop, once you've given your name, driver's license, you don't have to, and you should not answer any further questions.
Address,
yes. But anything beyond that, do you know why I stopped you? A lot of people say, well, I was speeding. You just made an admission. Where are you going? You don't have to answer that. What are you doing?
Not in Texas. You do not have to answer that question.
Not in Texas. So that's the traffic stop. Now, Dad, you were going to, let's say someone's just standing on the street outside of a store.
Yeah. And what you just said was critical. There are so many nuances here. But what you just holding us up a minute and making sure that we understand what we're trying to say here. So I'm a stress it a third time. You stress it. I'm a stress it a third time. So you get pulled over. Cop pull you over. Walk up to your car. You roll down the window. Hopefully, no weed smoke comes out of it. But
no, that come out, that's a little different.
I'll digress. Hopefully, you don't have bloodshot eyes and you've been drinking all day. Okay, that changes everything. Okay,
it changes. You still should ask for a lawyer, but now
still should ask for a lawyer. That's right. None of that changes. But the stop is going to be handled a lot different if those things happen, because you at that point you've given the officer probable cause to arrest you, basically.
Yeah.
All right. So we're assuming that you haven't done anything like that. There's no probable cause for the officer to arrest you or any of that. The officer felt that he had reasonable suspicion to stop you. So, but you haven't been doing anything of that nature. Okay. And you haven't been violating any law. And like Chloe said, the officer says, good evening, sir. License registration, please. All right. You're obligated to do that. Okay. Go ahead and do that.
And let's put this for black folks, Daddy. I would say, sir, I'm reaching for my license and my registration. May I do that? My hands are up here. May I reach to get it? Because we know a lot of these officers, they're trigger happy. They racially profile us. They assume we're dangerous. So you got to add that extra wrinkle as well.
Thank you. Mm-hmm. Thank you so much for saying that. because we see it every day. So, yes, officer, even though he told you to get license and registration, he or she, you still got, you, as Chloe said, you still should, sir, ma'am, I'm reaching over to get my driver's license and my registration. May I do that? Yes. Okay. All right. So I'm just getting it. That's all I'm getting here. All right. So here you have it. There it is. Now, you have fulfilled your obligations under Texas law. You've identified yourself. Okay. Now, as Chloe said, he goes further and says, well, where have you been? And you don't have to answer that question. At that point, the wise thing to do is to start respectfully asking a few questions yourself.
Mm-hmm.
Such as, officer, with all due respect, are you placing me on the arrest? May I leave?
Mm-hmm.
Well, just depending on what the officer says, if he says, no, I'm not placing you on the arrest, I am giving you a citation. Okay, well, then sit there and wait for the citation. But don't have a dialogue with the officer. That's where the problem comes in. Mm-hmm. Because if you voluntarily talk to the officer, he doesn't have to read you your Miranda warnings.
Yes.
Okay? So don't sit there and have a good old colloquy, a good old conversation. Start asking him or her some questions. Am I under arrest? May I leave? And hopefully the officer says yes. Or, no, you can't leave. I am going to write you a citation. All right. So if you're talking about a simple citation, just sit there and wait on the citation. If you know that you have been involved in something that you know, may get you in trouble, or you got something in the vehicle, anything of that nature, then if he starts asking you questions, that's where you should refuse respectfully to answer those questions. And you should ask, can you leave? If you can't leave, no, you cannot leave. I smell some marijuana, or your eyes look bloodshot, or what have you. All right, so now at this point, you've been detained. Okay, your hands are not behind your back yet. You're not sitting in the back of his car. But when he says you can't leave, you have been detained. And so at this point, two things ought to happen. One, he should at this point read you your Miranda warnings before asking you another question, because you're detained and now he's interrogating you. So he should let you know, he should warn you that anything you say at this point can and will be used against you in a court of law. And you have the right to an attorney. If you can't afford one, one will be appointed to you. So at that point, you know this has just got, when he says, no, you can't leave, you've been detained, this now has just gone to another level, and you need to do the first thing we said, ask for a lawyer. And then you need to do, after you ask for that lawyer, you need to do the second thing and be quiet. Respectfully. So,
and a lot of times on that point, Dad, what the officer would do is, well, why don't you just tell me what happened? See if I can help you. Or, you know, if you tell me what happened, I'll see what I can do with my supervisor.
Don't
Or let
believe
me
it.
help you help me. Don't don't do it.
Be quiet.
We have a question on YouTube.
Well, some people, before we go to that question, some people say, well, if I be quiet, then I'm going to get arrested. That's going to increase my chances of getting arrested. First thing I want to tell you about that is if there's probable cause, you probably already going to get arrested.
Yeah, at that point.
I mean, there's you talking is not going to prevent you from getting arrested. You talking is going to cause you to be probably in a lot more trouble.
Mm-hmm.
So it's best to just go ahead and get arrested, get bonded out, than to say something that they're going to use against you, and you're still going to get arrested. But now, depending on what they're investigating you for, you just gave them what they need to prosecute you and perhaps imprison you. Just about every case that we have where someone gets a bad outcome, oftentimes it is because of things they said to the police or to a detective. All right, so there are a couple of questions.
Yes. Shy fella, what's up? Thanks for joining us. He or she asked, are they allowed to put handcuffs on if you are being detained?
Sure.
That's a good question. Yeah.
Sure. Yeah. It's a matter of safety. They may take them off if they feel like there's no issue. But yeah, I mean, they're doing it to promote safety. So that, if someone has something, let's be realistic. It's dangerous being a police officer. It's very dangerous. I mean, a lot of police officers get killed, and they kill a lot of people. So it's just dangerous being out there in those streets. You never know who you're going to encounter. So yes, they can put those handcuffs on you. That's legal. And besides, if you don't think it's legal, or even if it turns out to be in illegal detention, Chloe and I fight those battles all the time. We have clients who come and tell us we were arrested, and we look at all the facts. We look at the body cam. We look at the dash cam. We look at witness statements. We look at everything when we are assessing these cases. And we may come to the determination, yes, we agree that he should not have detained you, and we'll deal with that in court. But don't fight that battle out on the streets.
Mm-hmm. Say before the court. Alicia said, hey, sis. She said, don't say anything respectfully. That's right.
Absolutely right.
Be respectful. Don't say nothing.
Always keep it respectful.
Yeah.
Just always, yes, sir. No, sir. Yes, ma'am. No, ma'am. Because you're trying to de-escalate the situation. We already know that there's tension between law enforcement and Black Americans. So we just got to do everything we can to keep it from going where it shouldn't go. Now, somebody say, well, we've seen people de-escalating matters. Like, I always think about Philando Castile, and he still got shot to death. It's true. It's true. Even when you do everything you're supposed to do to try to de-escalate the matter, try to follow the law, or everything we're telling you right now, and still get shot to death. We get it. But you by de-escalating the matter, you are increasing your chances of being able to walk away from that situation, and you are increasing your chances of an attorney being able to help you later on if the law, if the cop has violated your rights.
Yep. We have another comment from Nuvi. What's up? Thanks for joining. She says, if you think the cop is acting beyond his authority, just say, I do not consent to XYZ, and then peacefully submit to whatever they are doing. That's basically what we're saying. You want to make sure that you're...
I do want to say, I think Nuvi brings up a very good point. If you think the cop is acting beyond his authority, just say, I do not consent to, and then respectfully submit to whatever they're doing. Well, I don't know if I agree with that. Nuvi. Because remember, we're saying that you should be quiet and you should ask for a lawyer. So let's suppose they say to you, well, tell me what happened. I mean, that's a command from the police officer to talk. So we're telling you that is a command that you should not obey, respectfully. So when you say that we should peacefully submit, not all the time. You should not submit to his command to talk, because you have the right to be silent. You have a Fifth Amendment right to be silent, and you should exercise that right. So, but you're going to exercise that right respectfully. Officer, I want a lawyer. Okay, we're going to get you a lawyer, but I'm just trying to find out, what happened. And what should you do at that point? Be quiet. Okay, so you don't want to talk to me. You see what I'm doing? I'm not talking. So the officer says, okay, look, as Chloe indicated earlier, I'm just trying to help you out. And I can't help you out if you don't let me know what's going on. See, here's the thing. If you ask for a lawyer, but keep talking, you just waived your right to silence. When Chloe and I take that before the court is going to tell us, the judge, when we file a motion to suppress whatever else you said, the judge is going to tell us, but your client kept talking, Mr. Corbett, Ms. Corbett, your client kept talking. So I can't suppress that statement. That's a voluntary statement. So they did right by asking for a lawyer, but they didn't follow the second thing you said in your video, which is be quiet. They kept right on talking. Chloe, am I getting that to come across okay?
Yeah. So once you ask for the lawyer and you be quiet, don't talk after you ask for the lawyer, because basically you can waive, if you ask for the lawyer and then you keep talking, you can waive potentially keeping those, other statements from being heard in court. So ask for the lawyer, be quiet.
Now, Nuvi clarified herself, and she said that she's talking about, for example, a blood draw, but then she says a car search. All right, so let's look at those two things. All right, a blood draw, it depends on the state. In some states, and even in some counties, law enforcement can force you to give blood. Literally, physically force you to give blood. And then there are some other states jurisdictions where they would need to get a search warrant from the judge if you refuse. All right. So it depends on the state. It depends on the jurisdiction. But Nuvi's clarification that it's something like a blood draw, then yeah, if you're in a state or in a jurisdiction that can force you to do a blood draw, yes, keep quiet and don't fight that. Okay, don't be physically, no, you're not taking my blood. No, that's not a good thing to do. So yes, something like that where they can force you to do it, do that and do it peacefully. But still don't talk. Now, when it comes to the search, the car search, never consent to that. Capital Never, never consent to the search. You don't give us much to work with if you consent to the search. There may be something unconstitutional about the search that you don't see because you're not a lawyer, but we can see the moment we look at the body cam or the dash cam and we see a problem, but we can't really do anything with the problem we see because you ended up consenting. So never consent to the search. I wouldn't even consent to the search if I knew I didn't have any contraband in my vehicle or trunk or whatever. I still wouldn't consent. I just don't. I don't trust the system. I don't trust cops. I mean, they can plant something.
And they have all the time.
Exactly. Not to suggest every cop is crooked. Not saying that, but there are some. So I would want it on the record and in the body cam. I did not consent to that search. Now, one other thing, Chloe, when you're in the middle of these things, you know, your heart, your what do you call it? Your adrenaline is flowing, your testosterone, if you're a dude or whatever. I mean, you're nervous and all that, and sometimes everything we just said goes out the window. It was Mike Tyson who said, everybody got a game plan until they get hit in the mouth. It's very true. I mean, you heard us. I heard them lawyers say this and that, say that and that. And then as soon as that blue light comes on and that officer walks up to your car door, you forget everything we said.
Yep.
Just remember, ask for a lawyer. That's why we did the ABC, right? Ask for a lawyer. Be quiet. All right, we're getting some more comments here.
Alicia said, repeat yourself and say, I would like a lawyer, please. And thank you, sir or ma'am. Yep.
Yes.
Keep repeating it.
You know what? I don't know. I don't know if you need to keep repeating it. You look at what we said. We said be quiet. Because you keep repeating it, then once again, there's a case not long ago, back maybe 6-7 years ago, where the U.S. Supreme Court said that if you exercise your Miranda rights to be quiet, but you keep talking, even if you keep repeating it, you can waive that. You said it once. Hopefully, it's on the body cam that you didn't consent. I wouldn't keep repeating it because there's also the temptation. These are very skilled people. They know how to keep you talking. And so just a little bit more repeating it, and a little more this and a little more that. And before you know it, you have now gotten into sort of a dialogue unintentionally. You said it. Now be quiet. I'm looking at some of the other comments here.
Nuvi asks, have we seen the script from Pop Brothers at Law? I've definitely seen their videos. I
What is
agree.
that? What is Pop Brothers at Law?
It's the two attorneys. I think they said shut the F up.
Oh, yeah, I have seen them. Yeah. I mean that I don't use those kind of words. But that's essentially what we're seeing.
So they made a script. And it's basically what we said. You know, why did you pull me over? Am I being detained? Am I free to go? If they detain you, that's when you need to invoke your Fifth Amendment right to remain silent and ask for a lawyer.
Yeah, so I mean I've not watched them. I heard about them. I don't know anything about them, but that's if I use those kind of words, that's exactly the way I would see it. That's the way I feel it. You know, when we see our clients getting when we see them having to go to prison because of something they said, it's heartbreaking. So that's exactly the way I feel it. I just don't use those terms.
Well, you should have seen your face when I said it, Daddy. He was like, wait, hold on. But okay. Shy Fella said, what do you guys feel about self-recording to stop yourself?
Yes, do it.
Always.
Just do it safely.
Yeah.
I mean, don't pull your cell phone out and give them a reason to say you're reaching for a gun. Here in Texas, you can't do something like that if it interferes with the officer's duty. So you got to do it safely. You got to do it smartly. You got to do it. You have the right to do it. Now, they can't tell you you can't do it, again, unless it's interfering with something they're doing. But we definitely recommend that you, if you can, to record everything. Absolutely.
Yep.
And if you see somebody, an African-American person who's being arrested or detained or something, record it for them.
Mm-hmm.
I do that, and I may not even know the person. Okay, I sometimes I've pulled over a block away, pulled out my phone, just so if something goes wrong, we might can get this person some justice.
Alicia said, oh wow, good thing I now know. Yep.
Yeah. Yeah, a lot of people, you know, I remember that case. I want to say Scalia wrote that case. I'm not sure. So it's been at least back here before he died. And it was a shock. It sent a shock through the criminal defense lawyers bar when that case came out. So even if you ask for a lawyer and you don't be quiet and you keep talking, even benign things like, I already asked for a lawyer, any of that could waive your right, could waive your Fifth Amendment right.
Yep.
I remember one case I had before we started practicing together, Chloe. This guy had written out a confession before I started representing. When his mom came to get me to represent him, he had written a confession out, not just given it. He had written it and given it to the DA. She gave it to me. I was still able to get his case dismissed because of actions the police officer took when they detained him. It was hard. I had to fight and, it was a difficult case. But despite his later confession, the fact that the officer did not do the right thing at that stop, this guy just so happened to do what was right, I got that case dismissed.
That's good.
Okay. All right. So I guess we'll go to the C.
So the C addresses. So let's say you're following what we say you need to do. You've asked for a lawyer. You've invoked your Fifth Amendment right against self-incrimination, i.e., you're quiet, you shut up. You're still arrested. So the cop puts you in handcuffs, puts you in the back of the squad car. Now you're on your way to jail. What do you do at that point? That's what C addresses.
Right. Call your family.
Call your family.
And let me say very, very fast before we forget, when you call your family, do not discuss the case on the telephone because they are recording the conversation.
Mm-hmm.
And I remember one case in particular, Chloe, again, before we started practicing together. My guy was accused of XYZ. And I am, prepared to put up a strong defense. When I went to see the prosecutor, when I walked into the prosecutor's office, she was playing the tape of a conversation he had with someone on the telephone while in jail. She was playing the tape. She was like, "Mr. Corby, you may want to hear this." I said, "Okay, let me hear it." And yes, it was very damaging. Those calls are being recorded. Do not discuss your case. Just say enough to try to get out of jail, like mom, dad, husband, wife, brother, sister, friend, pastor, whoever. Please get to the bond company and get me out of here. But what happened? I am not going to talk about what happened. Just get to the bond company. That's the only reason I'm calling you. Just get me out. And okay, all right.
And let's describe that process when you're in the back of the cop car. You're being taken to the jail, because a lot of our rebels may not have been arrested. They may have had family members or friends have, and they may not know what the process is. So you're in the back of the squad car. They take you to the jail. They're going to do a preliminary search, and they're going to put you in a holding cell. Generally, this is the general practice here in Texas, in the counties that we practice in. Once you're in that holding cell, according to Texas law, you have to be put in front of a magistrate within 48 hours. So that means that within 2 days of you being in jail in the holding cell, you have to be presented to a magistrate, which is a judge inside the jail, who is then going to take a look at the evidence from the police and decide what amount of bond or bail should be put on your case. So that magistrate will say, "John Smith, I'm going to set your bail at $5,000. And in order for you to get out on bond, I'm going to associate various conditions with your bond, i.e., you can't take any drugs, you can't pick up any new charges, you can't go within such and such feet of another person." There's a whole list of conditions that these magistrates and or judges can put inside the jail. Once you get your bond, you're typically taken to another cell, and it's at that point that we suggest calling your family without discussing the details of the case, but asking them to get you in touch with a bond company if needed. So that's the process that we're talking about. Once the magistrate gives you your bond amount, you know how much it'll cost for you to be able to bond out of jail. Call your family then, and at that point, have them working on getting a bond company or them putting up the bond amount themselves so that you can get out without discussing the details of the case. Don't talk about what happened with the stop, with the arrest, why you think you're in there. None of that. Just coordinating with them to try to get into contact with the bond company so that you can get out. Once you get out, then you go talk to your lawyer. You can discuss all of that. So that's what we're talking about at this step.
Yes. Okay, are there any? Let me see. Phone calls here.
Nuvi says, I had a friend get a DUI and he started trying to say something about the case. And I just jumped at him and said, we can wait till I pick you up. Shut up. Yes. If he was calling you from the phone inside the jail and he was trying to talk about the case, as a rebel, you have this information. Don't let him talk about it.
Yes, someone asks, by law, when is this phone allowed? All right, I can't speak for other states, but Texas, it is, they must give you the ability to make a couple of phone calls, and they have a certain time limit they have to do it. But I cannot, again, talk about other states. I'm only licensed to practice here. I presume it's true in other jurisdictions as well, but certainly here in the state of Texas, it is. They must do so. They the way the statute reads, it says shall permit someone to make a phone call. So the word "shall" there would strongly suggest that they have to do it. If it says may permit, that's a whole different ballgame. But shall permit, yes, they got to. In a lot of states as well, and those phone calls are very, very expensive, extremely expensive. So you have to keep that in mind as well. But the main thing is, do not discuss the facts of your case. Well, that brings us to the fourth thing, I believe. Yes. Let's go back. Number 4, don't discuss your case with anyone.
That includes other people who are in the jail with you, the jail cell with you. We know
those jailhouse lawyers.
Those jailhouse lawyers.
Some of them are really jailhouse snitches.
Yes, because they're trying to get better deals for themselves. So you don't need to talk about your case with anybody inside the jail, outside the jail, not on the phone, no one but your attorney. Once you get out, that's it. So make sure y'all keep that in mind.
Yes, and that would also include someone who comes to see you. When we have made jail visits, we assume that not only assume that the telephone calls are being recorded, but we assume that, and by the way, by telephone calls, let me go back to something. Let's say a lawyer is on the phone with his client or her client in jail. Now, some would argue that that conversation is protected by attorney-client confidentiality. That's a little twist right there, Chloe. Right? So the client and the defendant and the lawyer are discussing the facts of the case on the phone, on the jail phone. It's being recorded. At trial, the state says, Your Honor, we'd like to offer in the evidence Exhibit 13, the jail call between the jail call by the defendant. Defense lawyer stands up. Judge, I object. This is attorney-client confidentiality. So on. That's inadmissible. That's protected. That's privileged. In the state of Texas, that conversation has been used against people.
Yep. That happened to a colleague of mine, lawyer colleague of mine. Had a case set for trial. The person was not given a bond. And what that means, guys, is if the magistrate doesn't set a bond, or the judge in the case that your court is out of does not set a bond, then that person has to be in jail until the case is disposed of, either by a plea deal, or by going to trial on the case. So he didn't have a bond. The trial was set. The lawyer communicated with him, via telephone, and the prosecutor tried to use those conversations against his client. And he had to put up a big stink, like went all the way up to the DA and all types of stuff to try to keep those conversations out.
I vaguely remember that.
Yeah.
What happened?
I honestly don't know. I know he got a lot of advice from a lot of defense attorneys. I need to check to see what happened with that case.
Well, yeah, and what I was going to say is, when we're in a jail doing a jailhouse visit, we assume that even when we're in a private room, most of the time when we were seeing a client, we were doing it between glass. Mm-hmm. So I'm assuming there are video cameras in here. Okay, so there have been times where we've told clients that, just yes or no, and we'll give them some kind of signal. Don't shake your head. Don't do anything. Just do this or that. Don't say anything. And there are other times where we'll ask for a contact visit so that we can be actually in the same room with the defendant, so that we can get him or her to write out a statement that we take out the jail with us, and so that we can get right in each other's ear so we can make sure that conversation is not being recorded. I mean, we behave as if, this is being recorded. So out of the abundance of caution, just assume that not only the telephone call, but even the conversation between the lawyer and the attorney through the glass, or even in the same room, is being recorded.
Yep. We take every precaution we can to make sure that no incriminating statements by our clients can be used by the state against them.
So let's go back. Don't discuss your case with anyone. You're in jail. So who does that include? Cellmates, mm-hmm. Detectives. Detective come over to see you and talk with you, see what you know. Nope, can't talk to you. Priest, pastor, imam, rabbi, cop, bailiff, correction officer. No one. No one means no one. Mom, dad, no one. Wait till you get out. If your attorney is visiting you and you can't get out on bond or something like that, and he or she is trying to build a defense for you, and you all really need to talk about it, then if that's your lawyer and you all got some kind of system to communicate, then that's one thing. Anyone else? No, don't do it.
And keep in mind, too, this is not legal advice. We're providing legal information.
Thank you.
All of this does need to be tailored to your specific situation, especially in terms of not discussing your case with your lawyer. Now, everything else, look, is our constitutional rights. You have the right to counsel under the 5th and 6th Amendment. You have the right to be quiet under the 5th Amendment, not to incriminate yourself. But we're calling your family and not discussing your case. We're just telling you it's in your best interest not to get into facts of your case when you're making these calls or talking with your cellmates about it, because those statements have been used against people. We've seen it up close.
Yes. Now, Nuvi asked a very good question. She says, assume those phone calls are privileged. Then she asks, what if another, so we got a scenario here, I believe, where an inmate is talking with his or her lawyer. But what if another inmate overhears that conversation to your lawyer? Can the state use the other inmate's statements against you, the other inmate's statements, okay? Or is that hearsay?
Great question.
Awesome question.
Great question. The first thing I would say is attorney-client privilege extends to the attorney and the client. And if a third party who is outside of the law firm or one of the associates of the attorney is privy to that privileged conversation, then that breaks attorney-client privilege at that point. So if in this situation, in this scenario, if the inmate is speaking with his or her attorney and another inmate overhears what is said, then privilege is broken at that point. Because of that, if the prosecutor gets word that somehow this inmate heard the conversation, then the prosecutor could possibly subpoena that inmate to discuss what he or she, to testify about what he or she heard. Now that brings us to the last question. Is that hearsay? Which is a great question. So for people that don't know, hearsay is basically a statement that someone says outside of court that is made for the truth of what that person is testifying about. I'm trying to break this down as easily as possible. Basically it's something you say outside of court, and the person who said it is not themselves on the stand talking about that statement right then. So for example, if I'm testifying, I heard John Smith told me that he went to the bank to rob someone. No, that's not a good example because that's no, okay. Let's say that John Smith told me that he saw XYZ commit a bank robbery. John Smith is not the person who's testifying right now. So me saying what he told me is hearsay generally, unless there's some type of exception. In this case though, if the inmate is testifying about what they claim that the other inmate told their attorney, I will argue, if I'm the prosecutor, I will argue that that is an admission by the defendant, so it should come in. What would your argument be, Dad?
All right. This sounds to me like the verdict.
Yeah, we haven't done it in a while.
Here we go. Well, it's not queued up. Lay the groundwork for that again. I want to cue that up. I want to have that. I want that. I want all of that smoke.
Are we arguing from the perspective of a prosecutor or as the inmate's attorney?
You brought the perspective of the prosecutor, so I'm gonna challenge your perspective.
Okay.
All right.
Okay.
So go ahead and just set it up a little bit more. Give me a moment to kind of get this set up.
So, Your Honor, I'd like to call John Smith.
Well, hold on. I mean, I it's not ready yet.
Oh.
Just kind of talk about hearsay generally for a second.
Okay. So again, hearsay is an out-of-court statement that someone says for the truth of what they're testifying about in court. And generally, out-of-court statements are not admissible in court. There are a lot of exceptions to hearsay. So a lot of times these statements do come in. But it's up for the judge to make the determination as to whether or not that hearsay statement should come in. But really, the purpose of it is because the right for a person accused of a crime to cross-examine witnesses against them is so important and is so fundamental to the law. The law wants the person who made a statement against the defendant to come in and to testify about that statement in court. And the purpose is that the defendant should be able to cross-examine that witness under oath. So that's why there is a general that generally hearsay statements are not allowed to come in. But in terms of the context of what an inmate heard from a defendant and their attorney, that throws in a different wrinkle. From the perspective of a prosecutor, I would argue, well, judge, this inmate is only.
Well, we're not arguing yet.
Okay.
I mean, we need to introduce it.
I don't have a strong argument for it. I'm just thinking off the top of my head.
Yeah, I mean, it's just it just keeps the conversation interesting.
Yeah.
But yeah, hearsay is an out of court statement that's being offered to prove the truth of the matter asserted. Right? An out of court statement that's being offered to prove the truth of the matter asserted. And so, as Chloe was saying, if someone says the light was green, someone witnessed an accident and said the light was green to the police officer, and the police officer puts that in the investigation report, and then one of the parties want to use that statement that witness made, the objection would be, no, that's hearsay. But let's change it and say the person said that there was a bird flying in the sky. And when the accident occurred, that made its way into the police report. and somebody object. One party, the attorney for one party says, no, we object, Judge, that can't come in. And the responding party says, well, Judge, we're not offering this statement to prove the truth of the matter asserted. We're offering this statement to show that the witness was looking in the sky and not really looking at the accident. That's the best I can come with off the top of my head.
Yeah.
Okay.
There's so much to hearsay. Wow. Yeah.
So much. Okay. So as I understand the scenario that she created, one inmate heard another inmate talking to the attorney, and the state now wants to use inmate A's hearsay statement.
Mm-hmm.
And I concur that because of that third person's presence, the attorney-client privilege was probably waived. So that inmate talking to his attorney should have told that guy, get away, leave. You cannot stand here. I'm talking to my lawyer. No. And then he would have, protected the attorney-client privilege, although it still could have been used if it was recorded or somebody heard it. All right. So, but Chloe, you took the position to make the conversation interesting that it's not hearsay, right?
No, I said yes, it's not hearsay because it's an admission by the defendant.
Okay. All right. Well, that's kind of a touchy, but let's go for it. No, it didn't work. Anyway, I would just argue that I would argue, in fact, that it's double hearsay, actually. Okay, I would say that it was hearsay when the first inmate made that statement, and it is hearsay, triple hearsay, actually, It's hearsay when it made it into the uh, investigator's report, and it's hearsay um, now coming out of the mouth of the person who's about to take the stand and say it. And there are no exceptions. Chloe, Madam Prosecutor, argued that it's an admission of a party opponent. Well, I would just make the counter argument that the defendant is not a party. It's not a civil case. Um, this is a defendant in a criminal case. I don't know how that would fly, but that would be my initial response. And so, therefore, it is hearsay. In fact, it's triple hearsay. It's hearsay what he said. It's hearsay what this inmate is about to testify on the stand. So we would ask the court to keep it out.
So we will see what the judge does.
Yeah, judge will do whatever the judge want to do with it. But yeah, so that was a great question. That's one of those good law school questions.
Yeah, it takes me back to law school. Guys, basically what law school is, taking the exams are getting a set of facts, like what Nuvi gave us, and applying the facts to the law that you learn. So the exams, a lot of times, are essay questions. They give you a fact pattern, and you have to analyze the fact pattern and apply the law, those facts to the law.
Yeah, Nuvi says quite often lawyers can just make a weak argument and hope the judge agrees. Sure, that happens. If the facts are not on your side, they're not on your. Look, you got as Chloe just said, you got the law and the facts. If the law is on your side and the facts aren't, then what's the old saying? Then you bang the table. I demand the judge. On the other hand, if the facts are on your side and the law is against you, then there's something else you do. I can't remember it, but
basically, if the facts are on your side, you argue the facts. If the law is on your side, you argue the law.
Yeah, either way, there's some theatrics involved.
Yeah,
there's some courtroom theatrics. So yes, Nuvi, that is true. Sometimes you're just dealing with a bad set of facts, or you're dealing with strong law on the other side, and it is what it is. You do the best you can. I remember in law school on one occasion, we were dealing with a situation, and the and the professor asked us what would we do in that situation. And I remember saying, well, there isn't anything to do. I mean, this is a closed and shut case. And the professor got irate with me. He said, no, you find something to do. You find an argument. What do you're a lawyer. You will be a lawyer. You got to find an argument. You got to find something for your client, something that's, of course, ethical and legal. He wasn't suggesting that we break the law or violate ethics, but there's typically something that you can hang your hat on, typically.
Yes.
Okay. All right. So, Chloe, yes, it's over. We're going to end this. I'm sure Grace is ready to get out there. I'm ready to get out there. So this was really good.
This was good. Those are the ABCDs of what to do when you're arrested. Ask for your lawyer. Be quiet. Call your family. Don't discuss the case.
Yeah, Nuvi apparently went on Google or something, and she found what I was trying to say. I think that's about right, Nuvi. Yes, the point is there's some theatrics either way. Okay. So, all right. Yeah, I really enjoyed this conversation. It was really good, Chloe, as always. you have the young mind and the sharp mind, and I do too by faith, but I'm the older guy. Yeah.
I also want to say this, guys, before we get off, if there are any topics that you all want us to talk about, to analyze, put it down below. Let us know. Send us a message. If there's anything that you would want us to expound on, whether it's related to criminal justice, we also do civil rights, we do family law, there's a custody issue, in terms of just broad topics that you would like us to talk about and analyze, let us know down below. With that, I guess we're going to end it. And
I just want to say bravo for the student loan forgiveness.
Yes.
Yes. All right. And for the whole conversation, and for the the comments and the contributions from the Legal Rebels, it was just really great. We really appreciate it. And yes, we're getting ready to sound off. It was good.
It was good.
Enjoy the rest of your weekend. You all like, share, subscribe. Like, share, subscribe. Like, share, subscribe. And thank you all for your support. We really appreciate it. This is a labor of love. We enjoy doing it. No one else is doing it, to my knowledge. So tell all your friends, get here with us. Saturday afternoons, between 2 and 3 Central Standard Time. We're out of here. Peace.
Peace.
Soul. Love.